Notices of motions for Bills Number 1, Human Rights Bill, Introduction and Second Reading.
I call the member for Newtown.
Speaker, I move that a bill be introduced for an act to respect, protect and promote human rights.
The question is that this bill now be introduced. All in favour say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it.
Speaker, I bring up the bill, an electronic copy of which has been provided to the clerk, and move that this bill now be read a second time. Speaker, it is my absolute pleasure that I rise on behalf of the Greens to introduce a human rights bill for New South Wales, the Human Rights Act Bill 2025. A Human Rights Act is a powerful way of protecting and promoting human rights, a tool to ensure dignity and respect for everyone in our communities is at the heart of decisions when we in this Parliament and the government of the day make them on behalf of the people of New South Wales. At a time when all of us are feeling the burden of divisions, local and global challenges, and financial, societal and environmental pressures, this bill seeks to do something in the interests of all people in this state, to unite us, to connect us, to raise the standard up, to aspire to ensuring dignity, respect and justice for all. A Human Rights Act in New South Wales would protect the rights of everyone, while at the same time promoting better understanding of human rights and empower all of us to seek justice if our rights are violated. A Human Rights Act brings together all of our rights in one place and will require public officials to respect them, and any laws introduced in this place will need to have regard for them. The bill that I am introducing today was drafted in close consultation with human rights experts, including some members of the Human Rights Act for New South Wales Alliance, which is made up of now over 102 organisations, many of whom I acknowledge have representatives in the chamber here with us today. Over the past 6 months, we have worked together to bring this bill to the House today. Let me say that it's not perfect, but it is a start. A very good start. However, the foundations on which this bill stands and the rights enshrined in it were not created by me. They weren't dreamt up by the Greens or the people who worked with us even on drafting this bill. The foundations on which this bill stands were laid nearly 80 years ago when the United Nations General Assembly voted to establish the United Nations Declaration on Human Rights. It is significant to note that there is a direct link between this very chamber, Speaker, and the establishment of the Declaration of Human Rights, because the vote in the General Assembly took place under the watchful eye of a former member for Balmain and New South Wales Attorney General, Doc Evatt, who in 1948 was the President of the UN General Assembly. And it is my great pleasure to have my Greens colleague and the current member for Balmain here in the chamber today while we introduce this Human Rights Act. It is clear that the strong connection between our local communities here in New South Wales and this very chamber to the international human rights that we are seeking to enshrine today remains strong. This bill has been drafted and is being introduced by me. Yes, one MP, and indeed I am a Greens MP for those who have not noticed. But it is important to note that the content is based on rights agreed all of those years ago, and that since those rights, the principles that underpin them and the mechanisms by which they can be best protected, upheld, realised and remedied have been advanced, expanded and adapted through countless consultations with communities, negotiations by experts and nation states to develop international instruments, and enacted, amended and tested in domestic laws here and around the world. There is a famous quote about human rights by Eleanor Roosevelt from 1958. And it is very relevant to the connection between international universal human rights and the connection to the responsibilities that this Parliament has and our responsibilities to the people of New South Wales. It states, "Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person. the neighbourhood he lives in, the school or college he attends, the factory, farm or office where he works. Such are the places where every man, woman and child seeks equal justice, equal opportunity, equal dignity without discrimination. Unless these rights have meaning there, they have little meaning anywhere. Without concerted citizen action to uphold them close to home, we shall look in vain for progress in the larger world. Decisions made by governments, no matter what side of politics they are on, have a significant impact on the lives of those living in our state. And government policies and services, or indeed the lack thereof, also intersect with everyone's lives. Every day, those working in public services, in our hospitals, our transport systems, our schools, our TAFEs, our aged care, our youth services, our emergency services, are making administrative decisions and acting in ways that can have significant and lasting consequences for people's lives. And yet, at present, there is absolutely no requirement for any of those making these decisions, developing these policies or implementing these programs or assisting with inquiries over the counter at Service New South Wales to even consider the impact that their actions will have on the rights of people in this state. A Human Rights Act will change that. We know that even those working in our public service with the best intentions are always constrained by competing priorities, limited resources, changing governments, different policies. And we know that when the pressure is on, the thing that can sometimes be forgotten is the dignity and respect of those who governments are elected and their services are designed to respond to and to serve. A Human Rights Act has been a political and personal goal of mine for a very long time. Before I was elected to Parliament Speaker, I worked at Amnesty International, and over 15 years ago, I was a campaign coordinator at Amnesty Australia during the consultation process that took place at a federal level to push for a Human Rights Act. I was a member of the Human Rights Act Alliance Steering Committee at that stage, alongside Egg Santo and the late Susan Ryan. At the time, then Labor Attorney General Robert McClelland appointed Frank Brennan, Mary Kostakidis, Tammy Williams and Mick Palmer to lead a massive human rights public consultation. That national conversation and a strong, coordinated, successful campaign convinced Frank Brennan, who himself wasn't a supporter of a Human Rights Act, to make a recommendation for the enactment of a Human Rights Act in Australia. The timing of that campaign, Speaker, couldn't have been worse. Kevin Rudd was ousted by Gillard, momentum was lost, and the report was never acted on. At the time, New South Wales political leaders were at the forefront of opposing a Human Rights Act in domestic law, and one of those most vocal opponents was Bob Carr. Which brings us to now, and why now? Because unlike back then, the timing now, Speaker, could not be better. In March this year, in Question Time, New South Wales Attorney General Michael Daly told the House that the government is always open to considering the issue and working constructively to determine whether this proposal is a course of action that is in the best interests of the people of New South Wales. Later that same day, the Sydney Morning Herald reported that former New South Wales Labor Premier Bob Carr, previously the strongest of opponents to a Human Rights Act, said that challenge for civil liberties justified us considering a New South Wales Human Rights Act. In addition to this, we have in New South Wales a Labor minority government, as you know all too well, Speaker, and indeed others on the crossbench do, with a constructive and collaborative crossbench who are willing to do the hard work, and a significant amount of civil society support, many of whom are in the chamber today. Furthermore, the New South Wales Labor policy platform ahead of the 2023 state election included a commitment to a community consultation into the introduction of further legislation to better protect the human rights of New South Wales residents when law is interpreted and applied. This commitment was subsequently amended to include further detail that the Minns government is encouraged to hold at an early date a community consultation into the introduction of further legislation to better protect the human rights of New South Wales residents when the law is interpreted and applied. Now is the time to progress this historic reform. Before I turn to details of the bill, I want to be clear that this is the start of a process. It is very much my hope and the expectation of many who are engaged with this issue that this bill will be referred to an inquiry for public consultation. Detailed analysis and considered debate are essential, and I am not therefore intending to go into details about every aspect of the bill here today. We must start the conversation here, but we must continue it and involve so many more people. What we have drafted and what we will be seeking support from this chamber to refer to a select committee is not something that we imagined ourselves. This bill did not come out of nowhere. Far from it. It is based on human rights protections that have been prescribed in legislation in this country and around the world, and in human rights instruments for decades. This specific bill owes a lot of its structure to the acts and charters that exist in other Australian jurisdictions, which have been in place for, in the case of the ACT, over 20 years. It also closely mirrors the structure of the draft bill presented to the 2024 South Australian Inquiry into Human Rights Legislation, which earlier this year made a recommendation that South Australia indeed enact a Human Rights Act. I acknowledge and thank the authors of that draft bill, Professor Matthew Stubbs and Associate Professor Sarah Moulds, who in the latter case has provided her direct expertise and knowledge with us that has been so helpful in drafting the bill that I'm introducing today. Because of this, it is the start of a conversation. And due to the constraints of time, I won't touch on everything, but rather I want to highlight some of the main elements of the bill so that we can start the conversation, particularly the rights that will be included, details of the establishment of the Human Rights Committee and the Human Rights Commission as contained in the bill, as well as address some of the other areas of interest. Part 2, Division 2 of the bill, Speaker, sets out the particular rights that would be protected under New South Wales law if the bill was passed, which include economic, social, cultural, civil and political rights. Set out from Section 14 to Section 44, this bill seeks to protect the following rights, and I'm going to list them. The right to recognition and equality before the law and freedom from discrimination. The right to life. The right to prohibition of torture and cruel, inhuman and degrading treatment or punishment, the distinct cultural, spiritual, political, social and economic rights of First Nations peoples, rights of children and protection of families in all their forms, the right to privacy and reputation, freedom of movement, freedom of thought, conscience, religion and opinion, the right to peaceful assembly and freedom of association, the rights of liberty and security of the individual, the right to humane treatment when deprived of liberty, the right to a fair hearing, rights in criminal proceedings, prohibition of retrospective criminal laws, the right to compensation for wrongful conviction, rights of children in the criminal process and the right not to be tried or punished more than once, the rights of victims of crime, the right to dignified treatment, the prohibition of slavery and freedom from forced work, the right to culture, the right to education, the right to health, the right to adequate standard of living and housing, the right to work and other work-related rights, as well as the right to social security, the right to property, and the right to a healthy environment. I want to be very clear that not all of these rights would be immediately realisable to everybody in New South Wales, as much as that would all be very lovely. The reality is that the concept of progressive realisation would apply, requiring governments to take the necessary and tangible steps toward progressively improving the enjoyment of these rights over a reasonable period of time. Where a right cannot be immediately fully realised, this should be clearly stated in the legislation, as we have recently seen in the ACT, where after 20 years of being in force, the Human Rights Act was amended in September to include the right to housing. Following the passage of a Greens private members bill, the ACT Human Rights Act now includes a section recognising that everyone has a right to housing, and sets forth the following aspects of this right as immediately realisable. The enjoyment of this right without discrimination. No one may unlawfully or arbitrarily be evicted from their home, and no one may have an essential utility service to their home unlawfully or arbitrarily withdrawn. Section 12.3 of Part 2, Division 1 of the bill sets out that some rights, including the right to an adequate standard of living and the right to a healthy environment, include a type of limitation known under international rights law as retrogressive measures, putting an obligation on governments to not take backward steps in relation to these rights. That said, these rights would need to be enjoyed without discrimination. As I have already said, I am not introducing this bill today with the expectation that it will pass in its current form. I am sure there are a lot of human rights and legal experts sitting in the audience that would feel very nervous if that was to happen today. It is important for there to be broad public engagement, scrutiny, discussion and debate about what a Human Rights Act for New South Wales looks like. But what is not up for debate is the benefit that it will bring to the people in our communities. We know that any potential human rights legislation needs to be the subject of robust public inquiry so that feedback can happen from as many stakeholders and diverse community members as possible into the process, but also so that people feel like they are part of and own the development of a Human Rights Act for them. In September this year, we started that process in New South Wales with some amazing young people from Sydney and the Central Coast and Newcastle who came together for a youth forum in Parliament. Students from the Sydney and Hunter regions developed an incredible plan for human rights. In a resulting statement on human rights, the student urged representatives of this chamber in this place to support a Human Rights Act. They said, "We also call upon the New South Wales Government to protect our right to participate in law and ensure that we are consulted when decisions are being made that affect us. With good learning opportunities and access to decision-making processes, young people can helpfully advise on decisions and contribute more to our communities." With that in mind, there are some specific sections of the bill that we already know would require further ventilation and consideration through a public consultation process, foremost of which is Section 17 pertaining to the distinct rights of First Nations peoples. It is crucial, Speaker, and important that First Nations people and organisations are able to provide their input on this section, and I thank those who have already shared their expertise and their experiences with us to get us to this point in the drafting process. We also anticipate that there will be much public interest and discussion about Section 22 pertaining to freedom of thought, conscience and religion, particularly as it relates to Article 19.4 of the International Covenant on Civil and Political Rights. There is always a challenge when drafting domestic laws that reflect and enshrine international human rights conventions and covenants about how much detail of the original convention to include in the Domestic Act. One way that we have sought to address this and reflect this is through the inclusion of Schedule 2, which clearly lists sources of international human rights law. But that conversation will be up for debate, and we may end up with a very, very long act at the end. But I would encourage those who want to see the detail put in to remember that first and foremost, this is a law for the people. And so it is absolutely essential that that law is accessible and able to be engaged with by people that do not have masters of human rights or indeed decades of human rights experience. Similarly, close consideration of Section 28 relating to the rights of children in the criminal process and of Section 29 subsection 4, which relates to the publication of judgments in civil and criminal proceedings unless the interests of the child or victim requires the judgment not to be made public, need to be looked at. It is important to ensure that the latter does not impede with existing protections for sexual violence complainants, for example in Section 578A of the Crimes Act. The bill will establish both a parliamentary committee on human rights, Speaker, and also a New South Wales Human Rights Commission. I would like to turn briefly to discuss both of those now. Part 4 of the bill seeks to establish a parliamentary joint committee on human rights, which would examine bills and statutory rules compatible with human rights and report to both houses of Parliament on their findings. This committee would also have the ability to inquire into any matter relating to human rights referred to by the Attorney General or of its own motion. Beyond the basic functions that I have outlined, the particular composition and indeed the procedures of the committee and the makeup of it should be subject for further discussion within an inquiry process to ensure that it is fit for purpose for New South Wales, and also a consideration of how it would intersect with other committees that have consideration of human rights as part of their remit, including the current Legislation Review Committee and indeed other committees like the Committee on Modern Slavery. Another consideration is also how the committee could best draw on human rights resources in our community. For example, whether it could also include an independent human rights expert, either as a member or as an appointed advisor, akin to the Federal Parliamentary Joint Committee on Human Rights structure, whose secretariat includes an external legal advisor. A Human Rights Act for New South Wales would not prevent the government of the day from introducing and the Parliament from passing any law that it wished to. Maybe that's what the Greens would like, but that is not what is being put here today. Instead, it would require a statement of compatibility to be included with all bills being put forward and considered by the Parliament. Currently, there is very little requirement for any of the laws passed in this very chamber to consider the human rights of people of New South Wales when we pass them. Part 5 of the bill would require statements of compatibility to be prepared for any bill introduced into Parliament or any statutory rule made by a minister. Such statement, Speaker, would need to assess whether the bill or statutory rule was compatible with human rights and if it would limit any human rights, specifically addressing factors set out in Section 12 of the bill. Again, to be perfectly clear, the requirement for a statement of compatibility does not preclude Parliament from acting on its legislative agenda. And as we have seen, much to the concern of some members of the community, we have seen governments both in Victoria and Queensland pass laws that are not aligned with human rights. It will not stop the Parliament from acting, but what it will do is create a conversation and expose the fact that actually a government is making a decision that will be in contrary to the human rights of the people. And they may choose to justify that. They may choose to proceed with it anyway, but at least the conversation and the consideration will be there in the debates that ensue. It would be my hope that sections 57 and 58, which set out the requirements for statements of compatibility, would receive closer consideration during an inquiry process, including, for example, the level of detail required in the statements of compatibility and indeed who are the experts that should be assisting members of Parliament when they're presenting bills to be able to prepare that statement of compatibility. Part 6 of the bill, Speaker, would establish a New South Wales Human Rights Commission, the specific function of which are set out in section 62 as to deal with human rights complaints under this part and to deliver efficiencies in dealing with the complaints. B, to provide meaningful remedies for contraventions of this Act at the lowest practicable cost. C, if asked by the Attorney-General to review the effect of the Act's statutory instruments and common law on human rights and give the Attorney-General a written report about the outcome of the review. To review the public entity's policies at the Commission's discretion and on the Commission's own motion to investigate any situation where the Commission suspects that an authority may not be meeting its obligations, to promote an understanding and acceptance and public discussion of human rights, to make information about human rights available to the community, to provide education about human rights, and this Act including education to young persons about human rights, and to keep a list of private entities that are able to opt in to be held to account through a Human Rights Act, to assist the Attorney-General in reviews, to assist the Attorney-General in matters relating to the operation of the Act and any other functions conferred on the Commission under the Act. Notably, the Commission would not function solely as a complaint handling body. It would also be equipped with powers to advise the Attorney-General, to review the policies and operations of public entities, and to educate the community, including students, about human rights, which is something that we heard from the Human Rights Youth Forum that took place, is that so many young people wish that there was more education about human rights. And actually, when you ask a lot of older people about human rights, they assume that all of our rights are protected in law, despite the fact that we have never enacted domestic law here in New South Wales. Clearly, at the inquiry stage, the intersection also needs to be considered of the Human Rights Commission and their functions with other commissions and relevant government agencies and bodies, including, for example, the Anti-Discrimination Commission. Finally, this bill seeks to establish a review process, something that I know, Speaker, is always close to your heart. Monitoring the effectiveness of the legislation, and indeed in Section 95, creating an obligation for all public authorities to prepare an annual report detailing actions that they have taken during the reporting period to further the objects of the Act and detailing any human rights complaints that they have received. Part 8 provides for review of the Act by the Attorney-General as soon as practicable after the Act has been in operation for 2 years, with Section 99 outlining the very specific nature of this review. And I won't go through all of those details, Speaker, but I will touch on the fact that one of the requirements of the review is that the review must consider how this Act could be amended to strengthen the rights of First Nations people in New South Wales to self-determination and free, prior and informed consent, consistent with the United Nations Declaration on the Rights of Indigenous Peoples, adopted by the General Assembly of the United Nations in 13 September 2007. I note that at a federal level, the Australian Human Rights Commission has recommended that if a federal Human Rights Act were enacted, it should be reviewed have an independent review process every 5 years, and indicate that we would not be opposed to a similar requirement in New South Wales. Given the intersection of this domestic law with international developments in relation to human rights, it is important to consider how we would continue to have that conversation in the public space and indeed in the Parliament as we see new rights and indeed new conventions developed. And I specifically point to, at the moment, discussions that are happening about the rights of victims, the rights of older people, and indeed the significant developments that have taken place in recent times around the rights of people with disabilities and also the rights of First Nations and Indigenous peoples as examples of how society moves on, and there's a need for our domestic laws to adapt and change as those things change. I deliberately left in the he reference in Eleanor Roosevelt's quote from 1958 as an example of how even at the best of times, when we think we're doing the most inclusive, wonderful thing as well, we can be excluding half or more of the population. And so I think it's important for us to recognise that nothing about a Human Rights Act and human rights protection should sit stagnant, but should be part of an ongoing dialogue and conversation in this chamber with the community and indeed with those people that are impacted. The time for a Human Rights Act is now. At a state level, we have seen successive governments criminalise peaceful protest. We have seen the increased incarcerations of First Nations young people, and we have severely seen the limit to the rights to strike and other types of protest and peaceful assembly and expression. At a federal level, we have seen our right and the right of future generations to a safe and healthy environment undermined, and we have seen successive governments working to undermine that here as a result of laws in this chamber. Internationally, we are seeing consistently abhorrent breaches of people's right to life, the protection of families, the prohibition of torture and cruel and inhuman and degrading treatment in global conflicts. The amount of division being felt in our communities and around the world right now cannot be underestimated. I think we are all exhausted by that level of division. I, for one, do not choose to use the phrase social cohesion as a way to talk about it, but I recognise that others do. But I think we all share and are united in our view that the amount of division and fighting at the moment needs to stop. And we bring forward this Human Rights Act as a way to try and unite communities, to recognise that everyone has access to these rights, to be treated with dignity and respect, and to open a conversation up that recognises that there are so many things that all of us believe need to be protected and enshrined in our laws, and so often the laws brought to this place divide us rather than connect us. First Nations people are still being denied the right to self-determination, and I want to acknowledge and stress that this is something that needs to be looked at in relation to the development of these laws. Older people, disabled people, and those in regional and remote communities are not being treated with the dignity and respect that they deserve, and a Human Rights Act can be a powerful tool for those people who are at risk of being mistreated by systems that don't work for them. The Greens and many supporters of the Human Rights Act do not claim that this would be the panacea of all things. We know that legislating human rights, sadly, does not mean that everyone will have access to enjoying all those rights immediately, or indeed that governments of the day will have to respect them. But a Human Rights Act would give a direct course of action when people's rights are denied, and it would require this Parliament and all public bodies to consider the human rights implications of every policy and decision that they make, something that bizarrely now is not actually legally required in any decisions made in this chamber or indeed in any part of our public service or public authorities. A Human Rights Act for New South Wales would require the Parliament to think about this. It would also give the courts the power to assess whether laws are compatible with human rights standards and to make orders for remedies if they're not. All of this would mean that politicians and public servants could more easily be held to account, but also in the long term, it could strengthen our faith in democracy by encouraging robust debates and promoting greater transparency and openness about the decisions that governments are making and about how policies are being decided that will impact the people that they're being decided for. Speaker, there is so much more that I could say in relation to human rights, and I really hope that this is the start of a conversation. I'd like to acknowledge the many, many people, Speaker, who have been involved in getting us to this point, and indeed many people that have been involved well before most of us were even talking about human rights. Particularly, I want to give a shout out and acknowledge Kerry West, the convener of the Human Rights Act for New South Wales Alliance and Vice President of the Australian Lawyers for Human Rights, Deputy Chair of the Human Rights Act Committee of Australian Lawyers for Human Rights, Claudia Robinson. Both Kerry and Claudia have worked with us collaboratively and been willing to answer my very non-lawyer questions on a regular basis to allow us to get to this point. I also want to acknowledge the incredible way that they are collaboratively working with so many different groups and navigating the really challenging way that we have to do politics in a minority government, Speaker, something that would be not new news to you, about how we do this work in a way that brings civil society together, recognises the power of different voices in a parliament bringing debates forward, but also the role to work constructively together with all sides of politics to do that. I would like to also acknowledge other members of the Alliance who have shared their wisdom and advice with us. Demia Hayden, Blake Cansdale, Kirk McKenzie, Melanie Morgan, Tim Roberts, Amy Maguire, Carmel Lee, Danny Fadul, Sarah Moulds, Emily Kukowski, Sarah Marland, Chris Holly, Lewis Hamilton, Andrea Lax, Nikita White, Simon Henderson, Kate Gould, Julian Lawrence, and Chris Haynes. We know that these individuals have made incredible contributions, but they themselves would no doubt want me to acknowledge the fact that they have just come lately in comparison to how long these campaigns have been going on. And so I acknowledge the more than 100 individuals and organisations who've signed on in support of sending this bill to a select committee to have an inquiry in New South Wales into the need for a Human Rights Act and the benefits it will deliver the people, and acknowledge the human rights elders, past and present, who have been long talking about this before we started this most recent campaign. I'd like to give a shout out to the Parliamentary Council team for their incredible efforts, who reminded me that usually this involves massive drafting teams and many years of process to get to the point of having this bill, and particularly say thank you to Annette, Richard and Michael. I'd also like to acknowledge that in the chamber today are two of my former Amnesty colleagues and human rights mentors, Katie Wood and Peter Thomas, both who saw me as a young human rights campaigner running my first national campaign for a Human Rights Act when I started at Amnesty. And to the Newtown Electorate Office team for continuing to serve the people who elect us on everyday issues that impact them, while at the same time delivering on big picture policy agenda that our local communities expect us to do. And a particularly shout out to Patricia, who I think deserves an honorary law degree at this point. Believe it or not, despite her human rights expertise now, Patricia is actually a housing expert, and she has now added this to her incredible list of expertise in developing policy and politics and ensuring the community is engaged at every step of the way. On the back of all these wonderful humans and countless hours of work, Speaker, I feel humbled to be the one that can bring this conversation to the chamber today, to start the conversation in New South Wales. But I want to assure everyone that I do not need to own this. What I want to see is a Human Rights Act for New South Wales. What I want to see is us working together to be able to achieve this across the crossbench colleagues, across the opposition, as well as across the government, and working with civil society organisations to get this done. We have a real opportunity right now to do this. I am very, very humbled to have been able to bring this to the chamber, and I absolutely commend the bill to the House and hope that this is the start of a conversation to see a Human Rights Act enacted in New South Wales. Thank you, Speaker.
I thank the member for Newtown, and I call the member for Bega to move that debate now be adjourned.